Greetings, everyone. Welcome to the Black Child Advocacy Network. My name is Tuni Cherie Pepra. I am formerly a children's attorney and also a civil rights attorney, particularly giving you advice in the field of child and family law. This vlog is geared towards Black parents who are particularly based in the United States. And really the purpose is just to give you the tools that you need, the legal tools you need in order to fight back and push back against the system of white supremacy as it exists in the United States. So today we're going to talk about an issue that many of you are going to deal with, although you probably never really thought about having to deal with it. That is, what do you do whenever you receive a call that you have been the subject of a report, or your child is the subject of a report made to Child Protective Services? And I said that you probably have not mentally prepared for this prior to it happening because you don't know that you're constantly under surveillance. Literally, the second that you bring a child into this world, if you are based in Western societies, and again, this is geared towards the United States of America, the second that you bring that child into this world, you are under surveillance. Doctors, nurses at the hospital at the time of your child's birth are watching you. When you go to register your child for school, administrators, teachers, they're watching you. When you just want to take your child out for a walk to the park, people are watching you. Law enforcement officers, social workers, you are constantly under surveillance inside of the United States system. And so that's why it's important, even if you've never received such a call or you don't think it's likely that you'll receive such a call, that you are prepared for what to do if that does happen. So I start with my article. I'll start with my article for this month on the website educationforusnow.com. The website is a free resource. You can go and read the full article yourself. But I start off with the history of these mandatory reporters that are constantly reporting Black families. And they're reporting other families. This is something important to emphasize. These issues pertain to all people, really, but we know that it pertains to Black people disproportionately just because of the many studies and the many publications that have been done that prove consistently that Black parents will receive a report for something that white parents many times will not receive a report for. It's just a disproportionate impact. Like many things in the United States of America, foster care, abuse, neglect, these things are no different. So we start the article off talking about the history of these reports being done by people who are professionals, particularly professionals who deal with children. So teachers, or if you're a children's attorney like I was, or if you're a social worker, many times these people, whenever they enter into these professions, they become mandated reporters by the laws of the state. And these all were a result of the legislation that came out of Jimmy Carter's administration called the CAPTA that made it mandatory for certain professionals to report any time that they suspected abuse or neglect. Now, again, let's emphasize, it's not that they have to know that there's abuse or neglect. If they simply suspect that abuse or neglect could be happening, they are mandated to report that to Child Protective Services. So again, the professions that are mandated reporters: social workers, healthcare professionals, teachers, child care providers, and obviously law enforcement, and other professions if your particular state decides to make a more general category. For example, I used to live in New Jersey, and in New Jersey, literally everyone was considered a mandated reporter. Now, are you going to lose your job if you are working at McDonald's and you don't report a suspected abuse or neglect? No. So realistically, does everyone see themselves as a mandated reporter? Probably not, but it is still a law inside of that state. So it's also important for you to know what mandated reporter professions are inside of your particular state. Now, the importance of this, though, is to remember every time you leave the house, you're under surveillance, because if any of these particular professions are observing you and coming to a subjective judgment that you are abusing or neglecting your child, again, you could be the subject of a report to Child Protective Services. So what do you do? Let's go through the basics. First, you must understand that anytime CPS is calling your home, calling for you, that they are mandated to investigate whatever report that it is, even if it is frivolous, even if it is completely nonsensical. They're just mandated to at least investigate each report. Now, they go through their own internal processes to decide whether or not the allegation or the report that was made is something that's worth pursuing. So, for example, if it's something that they would not even care whether it was true or not, then more than likely it will be administratively done away with. However, if the allegation is something that they deem would be a danger to your child, then they do have to go through and actually investigate it fully. So once a case is screened and gone through the whole process internally, then you will probably be reached out to by the Child Protective Services caseworker, and they will probably seek to interview you. Now, it's important to understand, technically, you do not have to talk to Child Protective Services, and I would say in some circumstances, I would not even talk to them, particularly if it's an allegation that's being made against you that implicates you. You do have a right against self-incrimination, so you should exercise that right if in your judgment this could be an allegation that implicates you as a parent. However, many times it is better to comply with CPS, the reason being, particularly if the allegation does not implicate you or if the allegation is just completely nonsensical, many times it will make the process go a lot more smoothly. One of the unfortunate circumstances that might occur if you are very difficult and the caseworker deems your child at serious risk is that the caseworker, if you're not compliant with them, might go and seek a court order in order to force you to comply with the investigation. And let me just tell you, generally, if you can avoid litigation, avoid going into a court, by all means, avoid it. Just deal with the caseworker one-on-one. So you have to make those judgments and definitely seek legal counsel if you have that available to you to make a determination on whether or not you can safely comply with the investigation. Now, when they're doing their investigation, there's also usually going to be a home visit that's going to be requested, specifically if the allegation is in regards to the child's safety. And in those home visits, once again, you do have the right not to allow CPS to enter your home. You have a right to not allow them to search your home. However, I want to also emphasize again that a lot of times it's just better to comply if you are comfortable allowing them to view your home and you don't think that it will implicate you to allow them to view your home. Many times that will just make things go more smoothly. Once again, if you're not complying with the investigation, they could simply go to court and ask for there to be a court order to require you to comply with the investigation. Now, by the way, let's say you go to court and you say, I'm still not going to comply with the investigation. What's the risk there? Well, now you're at risk of your child being removed from you. So you can see how not complying and not following the court's orders could be a slippery slope when it comes to Child Protective Services. Now, if people go into your home that are caseworkers and you feel like they're going overboard, basically, if you feel like they're looking in drawers and things that really they should not be looking in, you always have a right to end the visit. You have a right to say you cannot go into this room. You have a right to say, okay, this has nothing to do with the child. This is something that I do not want you to see. You have that right. And so again, use your judgment. Obviously, you want to prepare your home ahead of time, though, if you're going to allow a caseworker into your home to search. Now, let's get to what happens in the circumstance that follows. That is when the caseworker has reached a judgment after talking to you, after investigating, viewing your home. What are the likely outcomes of this investigation at this point? So one of the most likely outcomes is going to be that the case just goes away. So like I said, usually it will be the case that there's no proof of whatever allegation was made against the parent, in which case it will be administratively closed inside of the office. And in this case, thank ya, because you do not have to go further in your interactions with Child Protective Services. That's honestly the ultimate goal once they call you, is that they administratively close the case without having to go to court. Now, something else that could happen without going to court is they could deem that there is some type of safety issue, but that it does not need the pursuit of litigation, meaning they could implement a safety plan. And a safety plan is something that the caseworker might order you to do. So let's say, for example, you have to go to drug treatment, or you have to take parenting classes. You may have to take some type of nutritional class. It could be many different services that the caseworker will internally recommend. These, although they're not court ordered, I would definitely comply. In most circumstances, you should comply. The reason is because if they implement a safety plan saying, okay, we think that this is not in need of litigation if you follow through with these services, but you decide that you're not going to follow through, then the next step more than likely will be that the caseworker will file a complaint, or their attorney will file a complaint to bring this case into court. And this, again, is what you want to avoid by all means. You want to avoid the court overlooking your family and subjecting you to unrealistic scrutiny on every few months, having you come into court, asking you questions. Have you done this? Have you done that? Have you done this? Have you done that? And if you have not done it, there will be consequences for you. You want to avoid that. So unfortunately for some people, though, the result of an investigation or the failure to comply with those safety plan services will result in litigation. And in this case, the state's attorney will file for a case to enforce the service plan, or to basically force you to come into court and be mandated to do whatever type of services that they want you to do. So in this case scenario, it's again unfortunate, but it's not the worst situation, because as long as your child's living with you, the state does not have custody of your child. And we'll talk later about the ASFA time clock that starts ticking. There's a clock that starts ticking the second that your child is taken into foster care. You're not subjected to that clock because the child is still in your custody. However, you're being overseen by the court, and they're making sure that you comply with whatever services or recommendations that have been deemed necessary. Now, what's the risk if you don't comply with the court? Child removal, and that is the worst situation. And in some circumstances, just from the investigation, the initial investigation commenced by CPS, you could have your child removed from you if they deem that your child is in danger, and that a simple order to do services will not remediate that immediate danger. So in that situation, the state will take custody of your child. And like I said, a time clock starts, an ASFA time clock starts that says that if you do not get yourself together within a particular amount of time, that the state has a right to file, not just to have your child in custody, but to terminate your parental rights. So these are the more extreme circumstances. Yah willing, you'll never have to deal with these extreme circumstances. But everything really comes down to remembering your rights. You don't have to talk to anyone. Remembering not to implicate yourself. Remembering that you are the one who determines whether or not someone enters your home or not. And while it's wise to comply, it's also important that you remember that, hey, I don't have to let you do whatever you want, go wherever you want. I don't have to let you go beyond the scope of the investigation. And I'll actually add one more note on the fact that you do have a right not to talk. Do not overtalk. Specifically, if you're going to offer information to the caseworker that they're not asking for, do not do it. No matter how innocent you think it is, no matter how much you think it will help you, if they're asking for information, and if they haven't specifically asked you to provide information, do not offer that information, because many times we unknowingly can implicate ourselves when we talk too much, when we're too friendly. Remember again that these people are agents of the state, and they are there to surveil you and see if you are guilty of abuse or neglect by their subjective judgment. So for all of that, we have to be very careful in any interactions that we have with state authorities. So that really will sum it up for this month's article. Prayerfully, this was helpful for you. Again, this article, the full article, is available on educationforusnow.com, and I hope to see you all next month with a new subject that we'll be covering.